afternoon. It is Monday, April 13th at 12:46 p.m. I'm calling the Senate Judiciary and Public Safety Committee to order. We do have a quorum present. And I'm going to make just a brief announcement that by attending this hearing, you agree to adhere to the standard expectations and decorum of the committee as explained in the written document available with the committee handouts and any additional verbal instructions that I may add as chair. And with that, I'll call up Senator Johnson Stewart. We're going to begin with Senate File 2689.
Yes, please. Thank you, Madam. Whoops. Thank you, Madam Chair. Madam Chair and members, I have the A6 amendment I'd like to move immediately.
Thank you, Senator Johnson Stewart. So this is not the first stop. If you could just explain the amendment first, and then we'll go to the committee for adoption.
Thank you. And members, gratefully you remember that this bill was heard last year and passed through committee. We recently had a hearing in state and local government last week where it passed through to this committee. There have been several amendments to this bill, and they've been combined into the one you see before you, the A6. Last week in committee, we also amended the bill to appropriate or to include the appropriation that's been requested, and that was passed through state and local. So last week when we met in state and local, we did not discuss policy, only the appropriation. So today I bring to you the A6, which has several, it's a delete everything amendment, and it has several changes to the bill since last heard in judiciary. I'll walk through that if you're ready. Okay, excellent. So the first page of the A6 deals with the authority and outlines some of the new subpoena powers that are included in this bill, which would enable the Attorney General's, oh, by the way, this is a Medicaid fraud bill. I should have said that at the start. Section 1, Subdivision 1 would expand the authority of the Attorney General's office to execute subpoenas without having to go through county attorney offices or local law enforcement. It's important to note that in Section 2, in Section 3, Section 2 doesn't really have any changes to what you heard last year. Section 3 outlines the intent to defraud provision. That was an important piece of the amendment that we added to make sure that only those people who have shown intent to defraud are subject to the following provisions in this amendment related to penalties and claims. And so I do have some testifiers that can talk more specifically to the technical elements, but we'll continue walking through Section 3. We've also added some information, some provisions for penalties. You'll see those outlisted in Subdivision 2. And the Attorney General's office, who are my testifiers today, can talk about the recent meeting they had with the, what's it called? Oh, the Sentencing Guideline Board. And we added some of their recommendations in the provisions that are listed in Subdivision 2. Thank you, Attorney General. Then there's just some other information in that section that has to do with definition and restitution. Then we move all the way back to section, sorry about this, I'm actually walking through it. The section 7, sorry, is where you'll see the appropriation, and that's the piece that's already been passed through state and local government. Mainly, just in general, the other piece of this that is covered in the appropriation, this allows the Attorney General's office to expand the number of staff in their office as recommended by the federal government. And if you remember, the appropriations awarded in this bill are met with a 3-to-1 match by the federal government. So this is a really important bill. I'm very proud to sponsor it in the Senate. And with me, I have two testifiers from the Attorney General's office. Of course, our Attorney General himself, Keith Ellison, and Nick Wonka, the head of the Medicaid Fraud Unit.
Thank you, Senator. We will start with Attorney General Ellison. Welcome to the committee.
Thank you, Mr. Chairman. And allow me to also thank Vice Chair Verbatim and also Ranking Member Limmer and all members. We appreciate you so much for the hard work you do. So when people commit Medicaid fraud, they're stealing from our most vulnerable members of our community, our neighbors. They're stealing from honest providers. They're stealing from our government. And I believe firmly that investigation and prosecution is accountability, but it's also prevention. To just let others know that we will hold them accountable if they steal public funds intended for our most vulnerable members. I would like to thank our Senator Ann Johnson Stewart, who's done really a great job on this bill and has been working so hard, and also Representative Matt Norris, to introduce and shepherd through the updated version of the Bipartisan Medical Assistance Protection Act, the MAP Act, to provide more resources and tools for fighting Medicaid fraud. The MAP Act adds dedicated and specialized staff to our Medicaid Fraud Control Unit, bringing the number from 32 to 50, which is the recommended number by the people at CMS who audit programs nationally. Members should know that that Minnesota is just one of many, many other states, about 47 or 8 other states that have Medicaid control fraud units funded in part through the federal government and the state. We're asking for state appropriation of about 25% of the total cost of the program. The federal government pays the rest. And so with that, I'm going to just let you know that our Medicaid Fraud Control Unit is one of the best in the nation. I look forward to working with every member of this committee to give this vitally important unit more tools and support for fighting fraud in Minnesota. And members, I have a document which I'd like to share with you if you're interested in looking at it. It looks like just sort of a spreadsheet of dates and case numbers and venues. But what it represents is around 350 fraudsters who've been prosecuted and convicted for trying to steal money that we are responsible for, making sure it gets to the right people. And I offer it to you just so that you know that we are working hard every day. The unit that Nick Wonka leads is working hard every day. You know, there are discretionary decisions that I make as Attorney General, but there's one thing that's not very discretionary at all, which is to prosecute people who break the law. And Nick Wonka does a great job at that, so I'll leave the rest to him.
Thank you, Mr. Attorney General. Mr. Wonka, welcome to the committee.
Thank you. Good afternoon. I'm Nick Wonka. I'm the director of the Medicaid Fraud Unit, and I'm here to talk to you today about the provisions we're asking you to support and that are within your jurisdiction. First, we're asking you to support policy changes in the new Minnesota Statute 609-467. That includes amending the fraud statute to cover current gaps that it contains. Some judges, right now the statute, the theft by false representation statute criminalizes the false claim for reimbursement submission. Some judges read that very narrowly as only including false claims that are submitted. This statute addresses issues that our prosecutors face every day in district courts and help ensure that fraudsters can be prosecuted for all of the types of conduct that they commit. That's done by, as you can see, covering a variety of different types of fraud and the ways that fraudsters try to steal from the Medicaid program or escape culpability for their crimes. For example, intentionally concealing a person who is excluded or suspended from participating as a Medicaid provider, but's nevertheless running the agency. Falsifying material information on enrollment documents, forging healthcare records, intentionally destroying records after a lawful request. All of these are things that we see every day, and now they'll be explicitly covered by the statutes. And while these crimes cover expansive conduct, they still ensure provider rights are protected and we're not catching accidental mistakes. That's done by requiring that we as a state prove intent to defraud for these violations. Intent to defraud, that's a specific legal term, covers the mens rea or mental state that the state must prove a defendant has when the crime is committed. It's the highest level of mental state that exists, and our prosecutors have proven it before, and we will continue to do so if you provide us with this amendment. The statute also includes a new provision targeting the most egregious offenses over $1 million as a separate penalty provision, and upon the recommendations from the Sentencing Guidelines Commission, it differentiates between low-level offenders as well and has intermediate penalty provisions. This ensures the appropriate accountability for those who get obscenely rich stealing money that is supposed to be going to healthcare needs for the most vulnerable people in Minnesota. And there are new provisions regarding restitution and continuing offenses as well that will help us ensure that those offenders are ordered to pay back all of the money that they have taken. The remaining provisions ensure that we still have original jurisdiction for these offenses and grant us subpoena power that is consistent with that of county attorneys when they're conducting criminal investigations and the Department of Human Services when they're conducting administrative investigations. State agencies like DHS have the authority to subpoena these records. The federal government also has the authority when it conducts healthcare fraud investigations, and granting us this authority aligns us with these other investigative entities and is consistent with the judgment that all investigating authorities should have equal power to subpoena financial records and other records when they're investigating providers for defrauding public programs. So that's the bulk of our requests, and we'd ask that you pass these statutes into law and enhance our ability as a state to investigate and prosecute so that we as a state can hold fraudsters accountable. Thank you.
Thank you, Mr. Wonka. Senator Johnson Stewart, did you have any other presentation before we go to committee questions and discussion?
Mr. Chair, I do not.
All right, so let's open it up for the committee. Any questions, conversations, discussion? Okay. All right. So Senator Limmer and then Senator Kroon.
Thank you, Mr. Chair. On page 1 of the delete everything amendment, we're expanding the authority of the Attorney General, and it lists a number, almost doubles the areas of which Attorney General would have authority, mostly in insurance and banking, financial records. Does this new subpoena power, does it negate any power of any local law enforcement?
Mr. Wonka.
No, it does not.
Right. Thank you.
Senator Kroon.
Thank you, Mr. Chair. On the subpoena power issue, same section, same page. Does this expansion of the Attorney General's subpoena power, is it just for Medicaid fraud cases, or is it across the board for all criminal cases?
Mr. Wonka.
The way that it's written is, if you look at Section 5, the banking, credit card, and financial records, those are limited to provider fraud investigations under 256B12.
Senator Kroon.
Thank you, Mr. Chair. Did you say provider fraud investigations?
Yes, Medicaid provider fraud. That's what the Medicaid Fraud Control Unit does.
So, Mr.
Senator
Chair.
Kroon.
Thank you, Mr. Chair. So under subdivision 1.5, that whole list of things would be just for Medicaid fraud investigations?
Mr. Wonka.
Yes, that's correct. It says that these are for the investigations conducted pursuant to the Attorney General's authority under Section 256B12, which is Medicaid provider fraud.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. 256B12 is just the Attorney General's legal representation for Medicaid fraud?
Mr. Wonka.
That's correct.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. How about subdivision 1, sections 2 and 4? Do those apply across the board or just for Medicaid fraud investigations?
Mr. Wonka.
Those are not limited to Medicaid fraud investigations.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. I don't know how long the Attorney General's office has been in existence, presumably since the beginning of our state. Is there a particular reason why these, I'm talking about subdivision 1, 2, and 1, 4 in particular, why those have not been included in the Attorney General's subpoena powers up until this point? And then the second part of that question is why are you asking in this bill for subpoena power beyond Medicaid fraud?
Mr. Wonka.
Some of these records are included in the county attorney subpoena statute, and for whatever reason, that has not transferred over into the Attorney General's office's statute. We conduct provider fraud investigations, we conduct criminal investigations, and this will give us consistent authority with other offices that do.
Senator Kroon.
Thank you, Mr. Chair. And then I noticed in one of the handouts, it says that the Medicaid Financial Crimes Unit, that the lawyers, people in that unit can only investigate and prosecute Medicaid fraud. My question is there anything in law that prohibits the Attorney General's office or the Attorney General specifically from transferring resources from other units into that unit?
Mr. Wonka.
The federal government needs to have a state match assigned in order to fund the federal match. So the way that the Medicaid fraud unit works is we get 75% of our funding from the federal government, 25% comes from the state. And that money needs to be specifically designated for the Medicaid fraud unit. We can't have people who moonlight there or only work part-time in the Medicaid fraud unit. That's contained in the federal regulations. And so that's why we are here asking you for this money to expand, so that when we go to the federal government with our budget, we say the legislature has dedicated this money to the Medicaid fraud unit, and therefore this is why we are eligible for the federal match for 18 people.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. And I understand that you can't have other lawyers moonlighting in that area, that they have to be designated in that unit to be eligible for the federal matching funds. But my question is there anything in law that would prohibit transferring resources in a permanent manner into that unit rather than asking for this additional appropriation and hiring new people into that unit?
Mr. Wonka.
Without going into all of the finances in our office, which I'm here to talk about Medicaid fraud, what I can say is the money has to be specifically dedicated in a manner that the federal government is satisfied that this is solely for Medicaid fraud.
Any further questions or discussion? Senator, who's next? We'll move Benton and then Senator Westrom.
Thank you, Mr. Chair. Thank you for the bill, Senator Johnson Stewart, and thank you to the Attorney General and your staff for being able to answer so many questions. That'd be helpful to get some of these pieces on the record, and I'm grateful for the conversations that we've had and some of the questions you've answered for me offline, but just want to bring that to the committee. Can you talk us through how you currently access some of these records, because you don't have the subpoena power? So maybe, for example, wage and employment records, what would the current process be? How long is that?
Senator Johnson Stewart.
Thank you, Mr. Chair and Senator Umuver-Benton. Before I hand it over to my testifier, I want you to know that I requested that the answer to your question in written form, and so if any of the members want to see that information, I have it. The Attorney General's office has been very gracious in answering every question I have, but I'm sure that Mr. Wonka can verbally explain that process as well.
Mr. Wonka.
So to answer that question, it depends on the type of records. I can tell you, where do you want me to start, I guess?
Senator Umuver-Benton.
Thank you, Mr. Chair. I'm thinking specifically about the records that are being added into this first section. So wage and employment records, insurance records, the banking, credit card, financial records, so on.
Mr. Wonka.
So the wage and employment records would be subject to the discretion of the of the employers. We can make a request for those records if they are not a Medicaid provider. So like, pick a multinational corporation. If we need wage and employment records, we have to make a request of them. If they deny it, we don't have any authority to get it. If someone's a Medicaid providers are required in their provider agreement to provide us with wage and employment records. However, if we're investigating that person, we're not going to make the request. We're going to go through a search warrant process. For financial records, it's more complicated. Right now, we can obtain through subpoena the existence and status of a person's financial records, but the contents of the account, we cannot under subpoena power. So for instance, if someone holds a account at Wells Fargo Bank, we can send Wells Fargo a subpoena saying, does this person hold an account there? What's their account number? That's it. We get that information. We can then either have, counties can subpoena this, or we can write a search warrant for it, which involves our investigators then taking the account number information, putting it into a search warrant, going to a judge, having that signed, involving local law enforcement in serving the subpoena on the bank, and then getting a return of those records weeks later.
Senator Umover-Betton.
Thank you, Mr. Chair. Thank you, Mr. Wonka. And then of these additional records that you are asking to have subpoena power on, does this exactly match what county attorneys can use subpoena power for?
Mr. Wonka.
I believe it was written that way. Without having the other statute in front of me, but that was the intent.
Senator Westrom.
Mr. Chair, to the testifier from the AG's office, if I could drill down a little bit more on the answer you gave Senator Kroon. It perplexed me a little bit, just your wording in response, so I wanted to figure out, is it possible you could use funds that you've already been given with great discretion to dedicate towards this type of fraud investigation in your department or not? And I was surprised by your caveat, and so I would like to know that answer just clear. You cannot do that is kind of what you left us with the impression of? Or is that your testimony today? You have no way to make money that we've given you discretion to spend to permanently dedicate it towards this?
Mr. Wonka.
That I can't answer that without talking to our finance people is what I'm trying to tell you.
Oh,
What
okay.
I can tell you is the money has to be 100% dedicated to the Medicaid fraud unit. I am not in the finance department in our office, but I can tell you I'm just trying to tell you what is required. We can't take people and have them work part-time here. They have to work full-time if we want to be eligible for federal financial participation, which is something that we want to do. We want to make sure that the federal government is matching 3-to-1 everything. So that's my answer for you. I'm sorry.
Okay.
If it appeared to be confusing.
That's more clear.
Senator
Thank you. And when you said without going into the budgetary, and then you kind of qualified it as no, but I think the answer seems like it should be yes, because we give the Attorney General very large amounts of money and some broad discretion with some of it to target where their need is, but appreciate your answer. Thank you.
Senator Seabrook.
Thank you, Mr. Chair. I have some concerns with regard to the language on lines 1.16 of the DE relating to insurance records. So if I'm hearing the testimony correctly, this expands beyond, for example, health insurance and would move into any insurance records related to claim settlement, whether they are held by insurance companies, law firms, people. Am I reading this correctly?
Mr. Wonka.
I don't have a clear answer on the latter one. It does say insurance records related to claim settlement. I can tell you this is identical. This one is identical to the county attorney's subpoena power.
Senator Seabrook.
So am I understanding it correctly then that we are using this bill relating to Medicare fraud as a vehicle to expand Attorney General subpoena powers simply out of convenience?
Mr. Wonka.
All of these provisions here are contained in the county attorney's subpoena power statute, and they're written in the same way so that the county attorney's subpoena power statute and the attorney general statute match. In the county attorney subpoena power statute, these are not limited to a specific type of investigation, but financial records are, which is why we have financial records here related to limited to provider fraud investigations and not expanded to all types of records. County attorneys can only subpoena financial records in specific types of cases, and so that's what we intend to do here, is to ensure that we have the same, or we have similar county subpoena power to county attorneys, and it aligns regardless of the investigating agency.
Senator Seaberger.
But this would expand the subpoena powers to investigations that are not just related to Medicare fraud, medical assistance fraud. Do I have that right? When it comes to the insurance records related to claim settlement.
Mr. Wonka.
That is correct in the same way that it does for the county attorneys, yes.
I guess I have concerns.
Seaver.
Thank you, Mr. Chair. I have concerns with regard to the scope of this. What I'm hearing is that this is an opportunity in combating Medicare, Medicaid fraud. We've made the decision to draft this such that we're not seeking insurance records related to claim settlement as it relates to Medicaid and medical assistance fraud. Rather, we're looking to expand it for investigatory subpoena powers for any purpose that are relevant to an ongoing legitimate law enforcement investigation. I have some concerns with regard to the scope of this particular subpoena power, whether it mirrors county attorney power or not. That is my concern. I would, have we adopted the DE? No,
Not
we have
yet.
not? Okay. I would move to amend the DE amendment by deleting Section 4, insurance records related to claim settlement.
Mr. Chair?
Senator Holmstrom, specifically to that motion.
If Senator Seaberger would be willing to withdraw her amendment, I have an A11 amendment that actually aims to do something very similar, using the language from line 1.20, limiting it to 256B.12.
Senator Seaberger.
Perhaps I could see the language of that amendment. I withdraw my oral amendment.
Anything further, Senator Seaberger, at this time before we go to Senator Holmstrom?
Nothing further.
Senator Holmstrom.
Thank you, Mr. Chair. I'd like to offer the A11 amendment.
Staff will distribute the A11 amendment.
Mr. Chair, would you like me to describe the amendment as we pass it out?
Yes, go ahead.
Thank you, Mr. Chair. So this would amend lines 1.13, section 2, after records, to add in the language restricting this authority to 256B.12, as well as lines 1.16 after settlement to add that same language, restricting it to 256B.12, which is Medicaid provisions specifically dealing with Medicaid fraud, just limiting the additional scope that we're giving the Attorney General to what this bill's intent really is. Thank you.
Senator Johnson Stewart, what's your position on the proposed amendment?
Thank you, Mr. Chair and Senator Holmstrom. I see this as a friendly amendment, so I'd be okay with it.
Mr. Attorney General, Mr. Wonka, anything you'd like to add? Mr. Wonka?
No.
So I do have a question about this. I certainly support the ability to get these records, wage and employment records and insurance records as they relate to Medicaid fraud investigations. But does the Office of the Attorney General engage in other investigations outside of the Medicaid fraud unit for which wage and employment records would be relevant and helpful in the course of that investigation, and for which insurance records related to claim settlement would be helpful and useful in pursuing those investigations? Mr. Attorney General.
Mr. Chairman, certainly it does. Absolutely. because we're here talking about Medicaid fraud and because I need this bill, I'm not going to complain. But look, the Attorney General's office is asked by counties all the time to prosecute cases and help them. We referred these cases. We have to rely on the county, those county attorney's offices to subpoena records that we need. If we can't get those records, then it adds an administrative burden. But if it's the will of this body that they maintain the status quo, that's just fine. I mean, but we're here on Medicaid fraud. The author was fine with it. And again, if Minnesota wants to stop Medicaid fraud, I got to get this bill through. So we'll go with what the members are willing to do, particularly if it's bipartisan.
Senator Johnson, Stewart, anything further with regard to the proposed amendment A11?
No, thank you, Mr. Chair.
Any discussion from members of the committee? Senator Holmstrom.
I'd just like to request a roll call.
There will be a roll call. Any further discussion on the A11 amendment? Not seeing any, the clerk will take the roll.
Chair Latz,
Yes.
Vice Chair Verbaeten,
Yes.
Senator Limmer,
Yes.
Senator Clark,
Yes.
Senator Holmstrom,
Yes.
Senator Kroon,
Yes.
Senator Pappas,
No.
Senator Seeberger,
Yes.
Senator Westlin,
Yes.
Westlin, Senator Westrom.
Yes.
There being 8 in favor and 2 opposed, the amendment is adopted. Is there any further discussion? Well, we've just amended the A6 amendment, so is there any further discussion on the proposed A6 amendment as amended? I'm not seeing any further discussion, so Senator Clark had already done it, right? Senator Clark, I understand you were prepared to move adoption of the A6 amendment as amended. Is that correct?
Yes, Chair.
Any further discussion on that? All those in favor say aye. Aye. Opposed? Motion prevails. The A6 amendment as amended is adopted. Is there any further discussion on Senate File 2689 as amended? Senator Kroon.
Thank you, Mr. Chair. I'm not going to offer an amendment on this. I still think that there's an issue with transparency in the Attorney General's office. My bill's been sitting on hold now for over a year. And while we're considering bills that expand the authority of the Attorney General's office, I think it would be prudent for this committee to take up transparency issues as well within that same office in the spirit of bipartisanship. And like I said, I don't know if this bill is the appropriate place to attach it to, so I'm not going to offer an amendment, but I just wanted to plant that seed for the committee that that issue is still out there. It's still important. And as we consider expansion of the authority to the Attorney General's office to combat fraud, we also need to make sure that that office is as transparent as it should be. Thank you.
Senator Kroon, as you know, I agree with you that conversations need to continue on that bill. I've encouraged you and Senator Clark to work on that, and I encourage the Attorney General's office to re-engage on that as well, whether the existing authority or some other mechanism is best. It's tough to balance a law practice and litigation with transparency to the public with ongoing litigation and the ability to cooperate with other public law practices, i.e. other attorney general's offices in other states for multi-district litigation, for multi-state litigation. I just encourage folks to continue to engage in that. And for what it's worth, I'm going to ask staff to draft up a bill for me to introduce that amends the subpoena power of the Attorney General's office in Section 8.16, Subdivision 1, to add in wage and employment records and insurance records relating to claim settlement without the restriction that we adopted here today. I voted for it because I think the bill needs to travel. And this is the best way we can address the Medicaid fraud issue for the bill to travel. But I do think it's just a waste of resources for the Attorney General's office, whoever the Attorney General is, to have to turn to county attorneys to go get subpoenas to get the records for the investigation the Attorney General's office is conducting. And similarly, a waste of resources when DHS has that expanded authority, when the AG's office has to go to judges to get them to review and sign probable cause statements, to get search warrants, all for the same thing that any other public investigating agency would have subpoena power just in the ordinary course of doing their job on behalf of the people of Minnesota. So I'm going to support the bill as amended because we need to address the fraud issue specifically, and I want to muddy that water. But I do support aligning the Attorney General's subpoena power with that of every other investigative agency that I'm aware of that has subpoena power to conduct their investigations. Sorry, Mr. Backus, just put another bill on your plate to draft up, but it should be comparatively simple compared to past requests from me. Any further discussion on Senate File 2689 as amended? Senator Clark, did you wish to make a motion on that?
I move we pass, move approval of the bill and send to, as amended, send to Health and Human Services.
So Senator Clark moves that Senate File 2689 as amended be recommended to pass and be re-referred to the Senate Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, members.
Thank you, Mr. Chair.
44.
Okay, members, next up, Senator Westlin, Senate File 4144, chemical irritants. So members, from a procedural history standpoint, we did already hear Senate File 4144. When it was last before us, we adopted the A1 amendment, which was a delete everything amendment. That is distributed along with the original bill as introduced for members to review. There were some questions raised that Senator Westlin promised to go back and get answers for us, and we'd bring it back here for a decision on what action to take. It is anticipated that there will be a motion to pass the bill as amended and refer it to the Senate floor. Senator Westlin.
Thank you, Mr. Chair, and thank you, members. As a reminder, this issue is actually traveling in two parts. There is a part of the chemical irritants bill that passed through the Commerce Committee that has to do with, that relates to other parts of this issue. The bill before us has to do with the notice requirements when chemical irritants are used. And there were some questions raised. The hour was late. We were all tired. And so I suggested that we lay it over. I'm going to do a quick walkthrough of the bill again, as it was amended from the DE amendment. And I think this answers the questions that were raised previously. In Section 1, Subdivision 1 is just a definitional piece. Subdivision 2 regards the data classification issue. This has to do with the fact that normally certain pieces of information might be classified under Chapter 13. This does allow peace officers, law enforcement agencies, and local units of government or in fact requires them to provide information specifically regarding chemical irritants, smoke screens, or distraction devices used. The question I think that we really landed on had to do with Section B and C, which actually addressed different parts of this notification process. Subsection B is the first part of the process. So law enforcement is on site. law enforcement has deployed chemical irritants or other items, there is going to be a standardized form, which is referenced in subdivision 3, lines 1.29 to 1.31, actually to 2.27. There's going to be a standardized form that will be similar to a notice that is left when a warrant is executed, for example. There's a one-pager that gets left on site. So subsection B requires that the standardized form will be left informing the owner or the occupant of the building that chemical irritants have been deployed, and it will provide them where they can go to provide further, to obtain further information. And it gives them information regarding who to contact. Then when you move on to subdivision C, this is step 2 of the process. Building owner, occupant has received this one-page notification that is left on site. The person says, I do have questions, I need more information about what has been used for purposes of getting site cleanup and so on. And then they will reach out to the agency indicated in the notification. And that is where that agency then will be required to provide more detailed information regarding precisely what has been used. And this really is necessary for the cleanup process. The commerce part of the bill actually had to do with the cleanup process, but this is our side of that, again, indicating that they are to get the information they need to pass on to the cleaning company or whatever agency will be coming in to do the cleanup and remediation. And as I mentioned, then subdivision 3, the Public Safety Commissioner will create the standardized notification that's going to be left under subparagraph B. So that is the bill as it has been amended. And again, just going back, what precipitated this bill really, Colin Hortman came to the legislature after their experience on June 14th, and the challenges he had, not only getting the appropriate information for what had been deployed in the home of his parents, but also challenges getting the home cleaned afterwards. And so we are passing both parts of this issue through Commerce in that bill and through Judiciary with this bill to ensure that in the future, innocent individuals who have these items deployed in their home will be able to get the information they need quickly and then are able to have the remediation and cleanup that is necessary. That is the bill, and I'm happy to stand for questions, but I think I think those were the primary questions as I recall them from the time that we heard this bill previously.
Thank you, Senator Westlin. Any questions or discussion on Senate Bill 4144? Senator Holmstrom.
Thank you, Mr. Chair. Senator Westlin, I do appreciate some of the updates you made to this bill. I think it's a standalone, a better bill than it was before. However, one of my primary concerns last time was that it required the peace officer who deployed the irritant to be the one that gives the notification and not just the department. Is there a reason that you didn't update that?
So, Mr. Chair and Senator, actually, this is exactly the same language that we worked on before. What it is the lead agency. So on a site like this, some mass event happens, there may be multiple agencies, but there's a lead agency, and there's actually a process in place to determine who that is. That was actually addressed in the Commerce side of the bill, but in speaking with the cities and cities and other agencies, they indicated there is a clear process in place as to who's responsible. And the notice is literally, what we're talking about is a one-page piece of paper like this that just says, we've utilized these items, here's where you call to get additional information. It's literally as simple as that. And so the lead agency on site would be the one who would leave that particular notice.
Senator Holmstrom.
Thank you. And I think that makes a lot of sense. My concern is that the language in my read of it doesn't indicate that it's the agency's responsibility, but simply the peace officer's responsibility. I guess maybe I'm being a stickler with the language, but that's what we do here in judiciary. So, but it says a peace officer who deploys a chemical irritant within a building must provide notice. That doesn't say an agency, it says the police officer. I guess I'm still stuck on that. I don't know what to say about it.
Mr. Chair.
Senator Westlin.
Senator, I guess I'm not sure what to say about that either, other than I understand that there's a chain of command that's happening in these situations, and I assume that there's a lead person in charge of the lead agency, somebody who deploys this chemical irritant is going to have to take a piece of paper and leave it on the property. I think it's really just that simple. My understanding, again, is having had a different discussion in the commerce part of this bill, is that there is a process in place for this to happen in terms of determining who the lead agency is. So I guess I can't answer it any better than that, Senator.
Senator Holmstrom.
Thanks. Now, I guess I would just follow up with, it doubles down on between line 112 and 113. The peace officer, not just the peace officer must notify the occupant of any unit. And again, I understand your intent, and I agree with your read of how it should be if this is passed, but the language just doesn't meet with what you're saying. If the language did, I wouldn't be saying it. I can't possibly create an amendment on the fly out of my head to make that make sense. There's a lot of language here that's referring to officers, and I'm not sure that I can get it right without gutting your bill, but I'll leave it there.
Any further discussion? Senator Kroon.
Thank you, Mr. Chair. Was listening to that exchange, and I do share the same concern. It is written to put the responsibility on the peace officer who deploys the chemical irritant, which may be routine or maybe completely not routine. I really don't know. But it would seem like if subdivision 2B would say something like, if a peace officer deploys a chemical irritant within a building, the law enforcement agency must provide notice of the deployment, and then change peace officer with law enforcement agency for the duration of subdivision 2B. And I think that would get at the intent of what Senator Holmstrom was referring to.
Senator Kroon, would it be your intent then that law enforcement agencies meeting that requirement could be satisfied by any of the peace officers that are within that agency actually being the individual to provide the notice or leave the notice at the site?
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. My intention there would be that the obligation would fall on the law enforcement agency as a whole. So anybody within that agency could be the one that gives notice to the occupant, and they would be complying with this, as long as it gets done. So if the officer who actually deploys the chemical irritant notifies their superior or designated person or whatever the policy is within that agency, and as long as that notice gets to where it's supposed to go, it's fine. It doesn't need to be. Now, in practice, maybe there wouldn't be much of a difference. As long as the notice is given, nobody's going to complain about who gives it to them. But in a case where the notice isn't given, it's the whole agency that's culpable, if you will, that failed to do it, and not just one particular officer who maybe quits the next day or something happens, and a variety of things can happen to one individual person. So I think it makes more sense for the agency itself to bear the responsibility.
Mr. Chair.
Senator Westlin.
This bill has been around since February. It has been vetted. It has been vetted by a number of stakeholder organizations. This part of the bill is very ministerial. It is literally taking a piece of paper with information and leaving it at the property. In the same way that if a team comes and they distribute a notice that a search warrant has been executed. It is a very simple process, and I probably would not be open at this point to changes to this bill because it has gone through significant vetting by a number of stakeholders, and we've had no objection from any, that I am aware of any of the law enforcement agencies. My understanding is there is a somewhat standardized practice, and I think that this is being complicated, Mr. Chair, in ways that I think are unnecessary.
Senator Westlin, what happens if the officer who deploys the chemical irritant gets injured in the course of the enforcement action and gets taken away to the hospital and is hospitalized for 10 days? If the obligation is on that particular officer who deployed the irritant to provide the notice, notice isn't going to get out under the statute for over a week. Was that the intent?
Mr. Chair, when the chemical irritants, I guess, I don't know if someone from law enforcement here can help us out. I assume when these things are being deployed, there's more than one person deploying them. It simply says that a notice has to be left at the property.
But that's not what it says.
And it
Senator
says
Westlin.
a peace officer.
And then the peace officer on line 112. I'm trying to parse this out
Yeah.
to figure out what the best way to do this is. Did we have a motion on the table, or was this just some suggested language at this point, Senator Croom? I'm trying to figure out procedurally where to go at the moment. Senator Holmstrom.
I'm happy to make that motion if council can help us draft it quick.
I think what I'm going to suggest that we do here is that we lay this bill over until we're done with the other bill and revisit this at the end of the hearing today. Give an opportunity for council to work on some language, and then we can talk about whether there's going to be any changes to it. That way we can fairly consider the question that is being posed for this committee to consider. And if there's any, if there's any other input, Senator Westlin wants to have time to gather. In the meantime, that'll give us a little bit of an opportunity for that to happen as well, and then we can address it before the end of today's hearing. So Senate File 4144 is laid over. Senate File 2533, Senator Mann. Okay, and Senator Mann, welcome back to the Judiciary Committee. I understand you have a testifier online as well. Members, this bill comes to us from the Labor Committee, and it is anticipated that this will be laid over. I think the expectation is for us to consider the the language, and there is, I understand, an amendment that's being distributed also with the materials to the members initiated by the author of the bill, I believe, Senator Mann. And then our committee will have had a chance to review this. And I think it's expected or anticipated then that the Labor Committee will take into consideration what we do when it will have formal possession of the bill, I think, or they're going to include some language possibly in a bill that they're moving separately. Am I describing that right, Senator Mann?
As far as I know, Mr. Chair, yes.
Okay. So why don't we start with you telling us a bit about what the bill does. And I think most of the provisions here are within this committee's jurisdiction as well. And then we'll go to the testifiers.
Thank you, Mr. Chair. So Senate File 2533 will prohibit stay or pay provisions, also known as TRAPs, or training repayment agreement provisions, also known as shadow student debt. These agreements require workers who receive, quote, on-the-job training, end quote, many times of dubious necessity, to pay back the alleged cost of this training if they leave their jobs voluntarily or involuntarily within a time range that can range from months to years, effectively trapping workers in jobs they don't want to be in. Some examples of trap agreements. Stacy, who is a nurse, she switched jobs between hospitals. The hospital she was working at had really poor working conditions. 3 years later, she gets a letter in the mail saying she owes the previous hospital $5,000 plus attorney's fees. Unclear exactly what the training she received on the job actually was. In nursing specifically, traps have been studied more closely, with studies finding that up to 45% of new nurses are bound by these agreements, versus just a quarter of nurses who were bound by them about 10 years ago. So across sectors, we know that the use of these clauses are increasing. Now, specifically in nursing, these agreements are more common and more egregious in hospitals where the markets feature a high level of ownership by private companies, private equity, and numerous reports suggest that hospitals with higher rates of unsafe working conditions and higher rates of unsafe patient conditions use these agreements more often, with payback amounts that range from $5,000 to $50,000. Some of the training described that costs this much money includes things like monthly webinars on stress management strategies. We have Casey from Ohio, who worked as a hairstylist. She was required by her employer to pay back training fees of $20,000 because she left before their arrangement was up. There's Jim and David, both truck drivers, who left the same company due to poor working conditions. One was charged $5,000, and the other one was charged $6,000 for leaving. Both stated that the training they received consisted of co-driving, so just sitting next to someone else on the truck. And one of them said that after this training, they still couldn't back up the truck due to the lack of actual training that occurred. And lastly, in the same company, we have a female truck driver who was sexually assaulted while starting her job. And when she told her supervisor, she was told that without a video, they couldn't do anything about it. So she quit her job because her trainer or her co-driver was the man who sexually assaulted her. She could not work and had to pay back $9,000 because of a trap agreement. So the trainings in question can range from preparation for recognized credentialing to very basic company-specific tasks that you can't take anywhere else, and they offer you no transferable skills. And the cost that the worker will have to repay can be completely invented by the employer and can include high interest rates, attorney's fees, and the ability for the employer to hold paychecks and retirement balances even. With that, Mr. Chair, happy to move to. Do you want to move to the amendment or to the testifiers?
Well, why don't we move to the amendment, because I know this is not an author's amendment per se, but it is your desire to put the bill into the shape you'd like to have everything discussed in. So Why don't you tell us what the A9 amendment does, and then we'll take it from there.
Thank you, Mr. Chair. So the A9 takes in feedback from stakeholders and from the discussion at our previous committee stop. It makes it clear that these prohibited provisions do not include sign-in bonuses, retention bonuses, relocation agreements, or any other payments made to the employee on behalf of the employer that is outside of the primary employment contract.
Is there any discussion on the content of the A9 amendment before we consider its adoption? I'm not seeing any. Senator Pappas moves adoption of the A9 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. All right, let's move to your testifiers, Senator Mann. We'll start with Chris Hicks, who I believe is joining us remotely. All right, you are on screen, Chris Hicks. Go ahead and identify yourself, introduce yourself, tell us your affiliation, and give us your testimony, please.
Thank you for the chance to testify today, Mr. Chair and committee members. My name is Chris Hicks. I'm a senior policy advisor at Protect Borrowers, a nonprofit organization focused on household and consumer debt. We're proud.
Mr. Hicks, is there a way you can get closer to your microphone? You're coming in very faintly here.
Yeah, is this any better?
A little bit, yes, thank you.
Okay, I'll do my best to project. Thank you for the chance to testify today, Mr. Chair and committee members. My name is Chris Hicks, and I'm a senior policy advisor at Protect Borrowers. We're a nonprofit organization focused on household and consumer debt and are proud to support Senate File 2533. My organization spent nearly 5 years studying the effects of stay-or-pay contracts on workers, honest businesses, and the broader economy. We've litigated several cases against the enforcement of stay-or-pay terms and have published numerous reports and legal articles on the topic, and frequently engaged in legislative advocacy related to these contract provisions. As the term suggests, stay-or-pay contracts are employment terms that force workers to pay their employer if they leave their jobs. These terms emit a chilling effect on workers who might otherwise assert their workplace rights. These clauses are forced on workers as a condition of employment, allowing firms to use the threat of debt collection or litigation to lock workers in place, limiting their mobility and bargaining power. When they do leave, these workers are often hit with a crushing financial penalty just because they had the audacity to quit their job. As Senator Mann just shared, one of the most common types of stay-or-pay contracts are training repayment agreement provisions, better known as TRAPs. A 2024 study from Cornell University found that 1 in 12 workers in the U.S. are subject to a TRAP today. These terms require workers to receive so-called on-the-job training, regardless of the quality or necessity, to pay back the supposed cost of this training to their employer when they leave their job. Often the purported cost dramatically exceeds the actual value of the training, and in many cases, the training is for the benefit of the employer rather than the employee. In other types of stay-or-pay contracts, employers have demanded departing employees pay them for the cost of their replacement salary, liquidated damages, or even lost profits. In response to comments regarding signing bonuses and relocation bonuses or benefits that have been raised in previous hearings, I believe that Senator Mann's amendments address these concerns while providing meaningful protections and often just common sense guardrails to workers. Employers would still be able to offer signing bonuses to employees, and the proposed amendments provide necessary protections so that employers cannot leverage repayment of these bonuses to keep workers from leaving. This includes not allowing any repayment obligation to accrue interest and requiring the repayment amount to be prorated and not to exceed 2 years from the receipt of payment. Thank you for the chance to testify on Senate File 2533 and its proposed amendments. And I'm happy to stay and answer any questions.
Thank you. Yeah, if you can stick around, we'll take the other testimony, and then if there are questions from members of the committee, you'll be available. Ryan Mick from Dorsey and Whitney, come on forward. Mr. Mick, welcome back to the Judiciary Committee. It's been a while.
Good afternoon, Mr. Chair. Thank you for having me. I will be very brief given the discussions that we have had. I am here on behalf of the Minnesota Employment Law Council, which is a consortium of some of Minnesota's largest employers. We certainly appreciate the effort and the intent behind this bill to prevent the sort of trap scenarios that the author, Senator Mann, has described. The concern that MELC and other employer-side organizations have raised has been that the original language in particular would have prohibited a number of mechanisms that employers have often used throughout Minnesota to provide benefits to employees on the condition that the employer's investment in those benefits could be recouped if the employee left. So MELC and others are grateful for the intent and the trajectory of the A9 amendment, appreciate the work that has been done there. We respectfully submit that more work is to be done. While the amendment addresses things like signing bonuses, retention bonuses, and the like, there are some other things that may well be within the intent of the amendment that simply aren't clear. So, for example, employers will often offer loans to employees with more than a 2-year repayment period, given the amount of the loan. Given the language in the A9, those sorts of loans with a longer term of repayment would not appear to be permissible. Likewise, employers may advance commissions. Or, as we're starting to see with the PFML benefit, you will see employers who will advance benefit premiums to employees who are taking this leave and simply don't have the resources to pay those insurance benefit premiums right off the bat. Those aren't amounts that are received by the employee. It's typically paid to the insurer. And so I think technically something like that wouldn't be within the language of the amendment. So we certainly appreciate where this is going, but would appreciate further the opportunity to work with the author and others to make sure that the full intent behind the amendment is achieved as we understand it. That leaves simply a policy question for the members to discuss and address in the way that you see fit. As much as there is no objection to legislative action to prevent traps of the sort that Senator Mann has described, it is equally common that you will have Minnesota employers who are best in class across the nation who will invest thousands of dollars in providing legitimate, genuine, transferable training to employees. And we respectfully submit for the committee's consideration whether there is a line at which you would allow employers to recoup those investments if an employee takes that training. It's not a credential, it's not tuition, it's not college credit, but is nonetheless valuable, and then takes that training, says thank you very much, and leaves. I think there is a creative policy way to certainly achieve the ends that Senator Mann has admirably presented to the committee, while also, in the discretion of the legislature, allowing employers to recruit genuine investment in employees to give them transferable skills. Happy to stay for questions. Appreciate the committee's time, Mr. Chair.
Thank you. Mr. Mick, I have a question. Do you have any language that you suggest to strike that balance as you're describing, or have you shared that with Senator Mann?
We saw, like the committee, the A9 amendment about an hour before this started. We have not shared language, certainly on the first part of my discussion in terms of loans or commission advances or the like. That would not be overly difficult. We could certainly provide that. I have also not shared language with the author attempting to address the policy balance between traps and the anecdotes that Senator Mann described, and situations where genuine investments might be legitimately recouped. I would be happy to work with Senator Mann on that.
It sounds like there's a real problem here that needs to be fixed. The question is, how do we fix it? Right? So, and the legislative process is moving quickly here. So if there's going to be, I guess if you want a hand in the language, now's the time to draft something and propose it. So I'd encourage you to do that. Time is of the essence.
Understood, Mr. Chair. Thank you.
I don't have any other testifiers signed up, so maybe while Mr. Mick is at the table, we'll just see if there's any member questions or discussion for him at the moment, or for Mr. Hicks that is still on board remotely. Senator Kroon.
Thank you, Mr. Chair, and I'm still trying to work through the A9 and understand the implications of the A9 because I read the letter, Mr. Mick, from your organization, or from you, I guess, and you cited a lot of examples in there, and I'm just trying to figure out which of those specifically are addressed in the A9 and which aren't. I guess my focus is on, like you said, transferable skills, education, certifications, those sort of things that where employers want to invest in their employee. If that is prohibited, I can't think of a better way to prohibit employers from investing in their employees, which certainly would not be good public policy, it seems to me. We want to encourage employers to invest in their employees, and when they're providing something that is transferable, they of course are going to need some sort of reasonable protections, or the employee could just decide to go work for their competitor or whatever after you've invested thousands of dollars in some transferable skill. Many employers will just choose to not invest in their employees if they don't have protection. So what about the typical education, degree, certification, is that, in your view, covered by the A9, or does that still need more work?
Mr. Mick.
Mr. Chair, thank you, Senator. By reference to the letter that MELC submitted on, I believe, March 2nd, I believe that the first engrossment and the A9 probably in large part satisfactorily address certification. If you offer tuition reimbursement for a certification or college credit, I believe that would be addressed reasonably by the first engrossment. I believe the A9 would reasonably address things like sign-on bonuses, retention bonuses, and relocation agreements, as referenced in the March 2nd letter. Respectfully, what I think the amendment and the first engrossment have not addressed among the concerns that we raised, again, would be loans, because that is not a financial benefit. And frankly, as I said, many of these loans are frankly substantial, and they're offered to employees as a retention or recruiting effort, or simply an effort on behalf of an employer to provide a benefit to an employee who needs it. But to the extent the A9 contemplates a 2-year limitation on being able to repay that, all of those loans would not be within the scope of this if, in fact, a loan is intended to be within the scope of it at all. It's not a bonus per se, but it is a financial benefit. I think among, again, the list of issues that we identified, things like immigration assistance, to the extent an employer is providing a benefit to an employee by making a payment to someone else. So if the employer pays an immigration lawyer to assist an employee with their immigration needs, again, I would much prefer clearer language, because that is not an amount of money that has been received by the employee. It has been received by someone else on behalf of the employee. And then again, it is distinctly unclear to me whether things like commission advances, health insurance premium benefit advances are within the scope of this. That may be the intent, but I don't believe it is clearly within the scope of the language. So those would be the issues that are still live, if you will, Mr. Chair, from the concerns that MELC and others have raised.
Senator Crum.
Thank you, Mr. Chair. And that immigration assistance is an interesting one, because I just had dinner with a couple that are immigrants, and they talked about, and they're in a specialized field, and they talked about the attorney's fees, the significant attorney's fees that they've had to incur. One, I don't remember all the details, but assuming, not to make it about the people I had dinner with, but you can imagine a scenario where sometimes the employee has to pay for those attorney's fees on their own, but sometimes if the employer really likes that employee and they really have a need for that employee, they're gonna front those and pay for those attorney's fees to keep that employee. And of course, again, they're gonna want some assurance that once, whatever status is achieved, and then the employee doesn't turn around and go work somewhere else and they've just spent all this money. And it seems to me it'd be good public policy to encourage employers to kind of front those fees because it might be cost prohibitive for a lot of employees to do that on their own. So I agree that that's a concern. So it sounds like the immigration assistance, employee loans still need some work, maybe some other things. But I appreciate your work and your testimony. Thank you.
Any further discussion? Senator Holmstrom.
In reference to this testifier or to the entire bill?
Well, whichever direction you want to go, Mr. Mick only sits a few feet away, so we can return to the table if it'll be useful for your line of questioning.
Thank you,
Senator
Mr.
Holmstrom.
Chair. I'd like to direct the committee's attention to page 2, line 27 and 28. As far as purpose statements go, this states that a stay or pay provision is unconscionable against public policy and prohibited. I think that that's really strong language, and it's clearly a purpose statement. It's an opinion. I don't think that that belongs in law. I'd like to see it stricken. I'm wondering if the author would be willing to consider that motion.
Actually, Senator Holmstrom, I think that language is taken from specific legal criteria that will be utilized by a court in reviewing and justifying or supporting the provision. But Senator Mann or counsel can maybe elaborate on that. Senator Mann?
Would counsel want to weigh in, Mr. Chair?
Ms. Primo.
Mr. Chair and members, I read that as a substantive prohibition on these sorts of clauses. And this wording tends to appear in a lot of other statutes that prohibit specific types of contractual provisions. And yes, it is somewhat a product of case law, but I believe this might actually need to stay in there to give effect to the substance of the bill.
Senator Holmstrom.
Far be it from me to argue with counsel on this.
Smart man. Any other discussion? Senator Westlin.
Mr. Chair, do we have anybody from the Chamber of Commerce or NFIB here that could testify to this? Or did they sign up at all?
No, they did not sign up. We can see if there's anyone in the room from the Chamber of Commerce or the NFIB. We have someone stepping forward here.
Okay. And while they're coming, Senator Mann, it just strikes me as this bill might have some significant unintended chilling effects of offering some of these loans or signing bonuses or things that really help sweeten a deal and make it easy for somebody moving from a current job to a new job. And so that's just an overarching concern here as I'm looking through it and listening to the testifier. But I guess I'd like to hear from more employers and small businesses that deal with this every day.
So, ma'am, thank you for coming forward. If you could identify yourself and respond to the question.
Thank you, Mr. Chair, members of the committee. My name is Lauren Schotthorst. I'm the Director of Workplace Management and Workforce Development Policy for the Minnesota Chamber of Commerce. We did sign up to testify in opposition, but the committee slots were filled for this hearing today. We testified in opposition to this bill when it was before the Senate Labor Committee a few weeks ago for the reasons you just mentioned, and appreciate the bill author's willingness to amend the language further in response to some of the concerns we identified during that hearing, but do still have concerns with the proposal in its total form and agree that it would have a chilling effect on business investment in their employees in Minnesota.
Senator Westrom.
Thank you. Would there be a list or some key issues that you still would have concerns with? And if so, I guess I would be interested for the committee to hear, or us to hear, as we're trying to work through these and not have chilling effects that or unintended, or that would put us at a disadvantage. Anything you can expand upon would be helpful, I think, as we're trying to work through this.
Ms. Schotthorst.
Mr. Chair, Senator Westrom, the blanket prohibition where this bill started is incredibly problematic. We appreciate looking to narrow the scope and come up with some reasonable parameters, working with Mr. Mick on some language that might help achieve the stated intent of the bill. But broadly speaking, we do oppose the underlying premise that these should be against public policy and prohibited.
So, Ms. Schotthorst, this bill was heard in Labor Committee 3 weeks or so ago. Has the chamber and anyone else come up with any language to solve what I think Senator Mann has identified as clearly a problem across industries, but put some guardrails around that, as you're suggesting, or you just deny that there's a problem?
Mr. Chair, the narrowing of the scope would be a good step. I think the identification of what should not be included is the right approach, but broadly speaking, the underlying premise is they should be prohibited, and we would disagree with that premise entirely.
Okay, so I think the answer is there's no language proposed, despite the last several weeks of this bill being out there, to try to narrow it, to still try to affect the author's goal here of getting rid of these abuses. All right, any further questions for Ms. Schotthorst or Mr. Mick at this time? Not seeing any. Thank you, Senator Kroon.
Thank you, Mr. Chair. And I don't know, Mr. Mick is I think, an employment law attorney, so maybe this is for him. But looking at page 4 of the first engrossment, I don't know if you have a copy of the bill in front of you, but the subdivision 6 civil action, it talks about employers or employees or prospective employees seeking redress for a violation of this section may, on their own behalf or on behalf of similarly situated employees or prospective employees, bring a civil action in district court. Is that getting at like class action suits? Why do you understand? Or maybe it's for the bill author. What is that seeking to get at there?
Senator Mann.
Thank you, Mr. Chair. It was just what we picked so that the bill could be enforceable. I mean, I'm not perhaps understanding your question.
Senator Kroon.
Thank you, Mr. Chair. I guess the similarly situated employees is the part I'm focusing on.
I can't tell if Senator Mann is contemplating a response or if there was even a question there. But I got a question for Senator Mann. You've heard some of the discussion here today, and the original bill was a pretty broad blanket prohibition, and the A9 amendment has introduced some carve-outs, if you will, and so maybe what we could hear is how do you address those? Do you think there's room for more carve-outs that would still accomplish your intended purpose? Was there a reason why it wasn't more broadly carved out? Or is the problem just so widespread that you don't think that much in the way of carve-outs can really solve the problem?
Thank you,
Senator
Mr.
Mann.
Chair. So I think both of those things. One, it is a very widespread problem that we're going to have to go in on an individual basis to see every single one of these instances, which happen across sectors. But the other issue is that we're also pulling in things that have not been considered trap agreements, like immigration payments, for example, technically don't fall under a definition of trap agreements. So we're being quite creative with what we're saying is now not allowed, which is certainly not the intent of the bill. But with the language introduced in the A9, I don't see how those things would be allowed anyways, including the immigration piece or the loans piece. However, if those are the two last sticking points, I'm happy to put in to talk to council and put in language to fix those two other things that keep being brought up.
So at least as identified, there were 4 things that were brought up. Loans, although frankly, you could just put an accelerated clause in the loan, I suppose, but still there could be an explicit carve-out. Advances on commissions, advances on benefit premiums, and payments made for immigration counsel.
Mr. Chair.
Senator Mann.
I would say that those last two things you mentioned are discretionary or unearned monetary payment, including bonuses not tied to the specific job performance.
So it's your view then, Senator Mann, that those would not be covered by this bill anyway, and so there should be no need to use language to carve them out?
Yes, but again, I'm happy to add more language, even though they don't technically fall under this bill anyways.
Yeah, sometimes just comfort language is enough to help make people feel better moving something forward. So, well, we've got, as I said, the intent was not to move this bill out of committee today. It was to have a discussion, try to work on language, and anticipating then that the Labor Committee would take the benefit of our work if they take up this language in any kind of a package moving forward. So I think what I'm going to suggest is that we're going to lay this over anyway, but we could revisit this. It's deadline week, right? We've got Wednesday, and if we can't finish up on Wednesday, we'll be here Friday. So my own inclination is if we can get some comfort language that addresses some issues that we could include within our work here in this committee, then that would be probably a good direction to go, and then we'll just complete our work without moving the bill out, if that's something that the chief author is comfortable doing. And then we could plan on revisiting this. I think I would aim for Wednesday. Our committee plan, our hope is to have the hearing on Wednesday and notice a bunch of stuff, and if we can move quickly enough through Wednesday and get it done, great. If we can't, we'll finish up whatever we need to on Friday. But I'd like to aim for Wednesday to have any cleanup on this bill. So Senator Westrom.
Mr. Chair, to the author, I think the language is probably that it's $5,000 per violation, but in addition to actual damages and reasonable attorney fees. Can you explain that more for us? Is that that doesn't resume every day that it's a violation or something like that? Does the 5,000 compound per violation, or is it a one-time extra fee, or price, penalty? Can you explain that penalty provision a little bit more?
Senator Mann, subdivision 6 on line 4.10, civil action.
Mr. Chair, my understanding that it's $5,000 per violation.
Senator Westrom.
And Mr. Chair, Senator Mann, is the violation every new day, or is it just a one-time violation?
Senator Mann.
One-time violation. It's not per day.
Any further discussion? Senator Holmstrom.
Thank you, Mr. Chair. Direct the committee to page 4, line 14. Speaking about the damages, it allows for $5,000 for each violation and reasonable costs and attorney's fees. I don't like the idea of adding reasonable costs and attorney's fees. I'd like to ask the author if she's stuck on that language or she'd be open to an amendment to remove those or that language.
Senator Mann.
Mr. Chair, I am not a trial lawyer, so I don't know the right answer to that. I don't know if council would weigh in or other lawyers in the room. I know there's many of you.
And like many lawyers, we have more than one opinion. It's not unusual to have reasonable costs and attorney's fees as part of a remedies section, but there's at least one attorney on this committee that prefers to enforce the American rule in every provision as well. So, as I say, there are different views on what the right approach is on this one. So, Senator Holmstrom, did you want to follow up with that in any way?
Yeah, I'd like to offer an amendment. I can offer an oral amendment to just delete everything after, replace the comma, the second comma on page 4, line 14 with a period, and remove everything that follows it. So it would end with just an additional $5,000 for each violation, period.
So Senator Holmstrom moves line 4.14 after the word, delete everything after the word violation except for the period at the end of the sentence.
Mr. Chair.
Senator Holmstrom.
I would also like to add into that on line 4.7 to add a period after the word section, and remove reasonable attorney fees.
Even though that's discretionary?
Yes.
Senator Holmstrom.
My fault. Remove 4.7 altogether. On line 4.6, replace the comma and add a period.
Okay, so Senator Holmstrom also seeks to amend line 4.6 after the word available, insert a period and delete everything else on that line and all of line 4.7. Is that correct, Senator Holmstrom?
That is correct.
All right. Any questions about the proposed amendment? Not seeing any. All those in favor say aye. Aye. Opposed? No. The motion does not prevail. Division has been called. Raise your hands if you supported the amendment. I see 5 hands. If you oppose the amendment, raise your hand. 5 hands. On a tie vote, the amendment does not prevail. Any further discussion on Senate File 2533 as amended? Senator Westlin.
Mr. Chair, Senator Mann, and it's something maybe that should get looked into, but I'm just reading some information from staff too, that the when you start factoring the Department of Labor penalizing in using this statute, it's possible that it could start racking up by the day instead of just per occurrence, and so that's a pretty big dollar amount per violation on top of day after day after day after day, if that would be possible. So I'm just raising that concern. I don't have language right now, but I was a little concerned about that, but I'm still concerned about it. Senator Mann, if you have any comment on that.
Senator Mann.
Thank you, Mr. Chair. I mean, the language says per violation, not per day, but that's all I got.
Senator Westrom.
So, Mr. Chair, Senator Mann, it's your full intent as the author that it wouldn't be an administrative penalty that would rack up day after day.
Mr. Chair, that is correct.
Okay, thanks.
Any further discussion? Senator Kroon.
Thank you, Mr. Chair, and I'm just going to, following up, I know Senator Mann didn't have an answer, but I'm maybe Mr. Mick does. I'm just trying to figure out if including in the civil action, an employer or a prospective employee can bring an action on behalf of someone else similarly situated, is that meant to be like a prerequisite for a class action? Is that supposed to supersede Rule 23 of the Rules of Civil Procedure? Why put that in statute? Does anybody know the intent of that phrase and why it should be in statute?
Senator Mann. Mr. Mick.
Mr. Chair,
Mr. Mick.
I certainly cannot speak to the intent. The language would indicate that a remedy is a representative one, or may be a representative one. Whether that would supersede Rule 23, I don't know. The language, the phrase "similarly situated" is often thought of in the context of class actions. It's also thought of in the context of FLSA representative actions, which are more of an opt-in rather than an opt-out. It is not clear how this language, to me, would specifically be interpreted by a court. That is, whether this would be a Rule 23 mechanism or something else. I suspect, but I don't know that it would be a Rule 23 mechanism. But yes, this is respectfully pretty clearly indicating that these would be class actions, or class actions could be brought to enforce this. Mr. Chair.
Well, Mr. Mick, that could be the case, no matter whether there's language there or not, right?
I believe that would be true, Mr. Chair, yes.
Senator Kroon.
Thank you, Mr. Chair. And of course, it could be a class action under Rule 23, and I think that's where it should stay. Unless there's some specific purpose, some specific reason it should be codified into statute. I think the rules of court, the rules of civil procedure should just play out the way it normally would. And if somebody wants to bring a class action, they would have to satisfy the prerequisites to a class action under Rule 23. I don't know how often we put this language in statute to signal or to maybe, put more balance on the scales towards, I just don't know why it would need to be in statute. So I think our rules of civil procedure are more than adequate to address that.
Senator Kroon, I'm going to suggest we ask counsel.
Okay.
Ms. Primo.
Mr. Chair and members, this phrase seems to appear in at least a few statutes related to employment law. I am not entirely sure how a court would interpret this phrase with Rule 23. I'm guessing Rule 23 would still apply, and in my search, there's at least one statute, 268B.09, that uses this phrase, but also states in the statute that Rule 23 applies to this section. So if the intent of the committee or the author is to, provide some clarity and still provide that, of course, Rule 23 applies to an action brought under this section, it may be helpful to amend that in as it is done in that statute I referenced.
We could have a situation where it's not a class action because there just aren't enough members of a class, but there could be 3 or 4 employees that are aggrieved by the same conduct, and you could have at least one of the lead plaintiff would have to be someone who is seeking redress for the violation. So I assume they'd have to be an aggrieved employee. And if they were going to do so, I suppose theoretically they could include 2 or 3 other individuals in there where you'd never get to enough people to get a class action under Rule 23. I think I'm going back 30-plus years to law school now, and we're probably all thinking back to our civil procedure classes, but the last I remember, the lowest class that had been certified that I was aware of was at 25 members or so. Usually they're quite a bit higher than that. So I don't personally, I don't think I'd want to limit it to Rule 23 application. I'm not sure it hurts to have that in there either. The person who's bringing the claim would have to be seeking redress for the violation themselves as well. Senator Kroon?
Thank you, Mr. Chair. I'm not sure I like adding the language in there about Rule 23. I think that the legislature doesn't need to be referencing court rules and all that into statute. So whatever that statute was that Senate Council cited, I'm not sure that's the best way to do it. And so that would leave between leaving it as is or striking similarly situated employees, which I suspect would not have the support of this committee. So with that, I think I'll just let it be.
Any further discussion? I'm not seeing any further discussion, so we have Senate File 2533 as amended. Members, I think what we'll do here is we're going to lay this on the table, but we're going to give notice now that it may come back up on Wednesday or Friday. If there's additional language that Senator Mann and other stakeholders are interested in bringing forward, we'll be open for that consideration on Wednesday, and if not, then on Friday. So with that, we're going to lay Senate File 2533 as amended on the table. Now, members, I did promise that we would revisit Senate File 4144. I understand there's some stuff in the works. I'm not sure if it's quite ready, so we may pause here. Okay, Senator Westlin looks ready to go, so we'll go back to Senate File 4144. Members, there is a proposed written amendment. We're going to send it out electronically to everyone while we are also printing it in the hard copies for members to look at. But while that is happening, we'll ask Senator Westlin to update us. Senator
Thank you, Mr. Chair. Thank you, members. So apparently there was one additional amendment that got engrossed in the other body that did not make it over to me that actually addresses all of the issues that have been raised. Once you get the A2 amendment, there's a couple of that seem to me in the nature of sort of drafting preferences. However, if you go to the heart of this is line 1.10. It is going to be amended to state that a peace officer from a law enforcement agency that deploys a chemical irritant within a building, or an officer from the lead law enforcement agency, if officers from multiple agencies deploy chemical irritants, and then I believe the rest of that paragraph I think for the most part is intact, just looking at it. This does address the concern about who is going to be leaving the notice. And again, my apologies, something got lost in the 20 emails going back and forth. Again, there seem to be a couple of other drafting choices that have been made that do not necessarily alter the substance. Line 1.18, the word on is changed to upon. Distraction devices throughout are being changed to diversionary devices. And then the other primary modification is a subparagraph E that is being added to state if officers from multiple law enforcement agencies deployed chemical irritants, smoke screens, or diversionary devices, the lead law enforcement agency must identify the other law enforcement agencies involved when responding to a request under paragraph C. So again, and then I think the other primary is on 1.28. At the end of that sentence, we're striking the period, and it says deployed by a peace officer employed by the law enforcement agency or local governmental unit. I believe that those changes all address the concerns that have been raised. It makes it clear that an officer from the lead agency on site, if there are multiple agents, or a peace officer from a law enforcement agency that deploys it. So it's not the officer who deploys it. And I believe, Mr. Chair and members, that addresses the concerns that were raised by members.
Thank you, Senator Westlin. Is there any discussion? Senator Kroon, you have been, and Senator Holmstrom had both been talking about this issue. What is your response to the A2 amendment?
It appears to, thank you, Mr. Chair.
Senator Holmstrom.
It appears to cover or explain if there's multiple agencies, but I don't think that on my first read here that it accomplishes the goal of alleviating the responsibility from an individual and placing it on the agency. It seems to be still keeping the responsibility on the individual officer unless there are multiple agencies involved. And then it also doesn't address on line 1.12 where it says the peace officer. So it doesn't seem to alleviate the original concern.
Mr. Chair, Senator.
Senator Westlin.
So it now reads a peace officer from an agency that deploys. So that any peace officer from an agency that deploys something. It's not saying a specific officer. And the first line, as it's been amended, 1.10, with the additional language, now modifies everything that follows after that. So it is not saying a specific police officer. It's just saying if an agency deploys it, then an officer from that agency should leave the notice.
Senator Holmstrom.
Thank you, Mr. Chair. I agree that does clear up line 1.10, but on 112, it's still using the phrase the peace officer. I would propose an amendment to change the into an or a police officer, a.
Senator Westlin.
Mr. Chair, I would like to adopt the A2. I would like to move the A2 amendment as drafted. This version of it has in fact been reviewed by law enforcement. I have been assured that that is the case. Again, I apologize that this amendment didn't make it to me before I brought the bill back up. But I have checked and I have been reassured that the changes that have been made at the request of law enforcement and that they are happy with the language as it has been adopted. So I would actually prefer not to make any additional changes to it. And I believe that the modifications that are presented in the A2 actually address the issues.
So why don't we start by considering the A2 amendment as it's drafted, and then we can consider anything further beyond that. Senator Westlin moves adoption of the A2 amendment. All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails. The amendment is adopted. Okay. Now, Senator Holmstrom, how did you want to approach the question that you just raised?
Thank you, Mr. Chair. And I'm glad to hear that stakeholders were involved. This body, this committee is meant to have these conversations and deliberate on these things. I don't believe that changing the to A is going to be a problem for any stakeholder. So I would still move that we amend the bill to, or let's see, line 1.12 after, or change the one, two, sorry, three, the fourth to an A. On line 1.12, change the fourth to an A.
Senator Holmstrom moves on line 1.12 before the word peace, delete the word the and insert in its place the word a. Senator West.
I'm not going to bicker over an A, but I'm not going to accept any additional changes to this, Mr. Chair. I will agree that that's a friendly amendment.
All those in favor of that amendment say aye.
Aye.
Opposed? Motion prevails. The amendment's adopted. Any further discussion? Senate File 4144 as amended. On I'm not seeing any. Senator Westlin moves that Senate File 4144 as amended be recommended to pass and be referred to the Senate floor. All those in favor say aye.
Aye.
Opposed? Motion prevails. All right, members, we will reconvene on Wednesday, April 15 at 12:30 or immediately following the floor session if it runs into our starting time. And you should keep Friday open in case we need it. We are adjourned.